Hello, my name is Margaret Martin. I'm from the University of Western Ontario. It is my distinct pleasure to introduce to you our first speaker, Professor Juan Carlos Bayón. Professor Bayón is a full professor at the University of Madrid. He has published extensively in leading journals in Spain. In 1991, he published a book entitled The Normativity of Law, Legal Obligation, and Reasons for Action. In this book, he explores the manner in which social practices can give rise to reasons for action. Building on this foundational piece of work, he has written numerous articles that focus on the various debates surrounding legal positivism. For instance, he has examined some of the main theses forwarded by Joseph Raz, including the idea that law gives us exclusionary reasons for action and Raz's theory of authority. He has also waded into the debate between inclusive and exclusive legal positivists. In his recent book, which he co-authored with Jorge Rodriguez, Professor Bayón offers us his thoughtful reflections on the nature of legal reasoning. In his chapter, Why is Legal Reasoning Defeasible?, he lays out the familiar answers to this question with great precision and proceeds to draw out the implications of each. He argues that all the familiar accounts lead us down two equally undesirable paths. We find ourselves in the world of wholesale indeterminacy or in the world of particularism. His own account of legal reasoning preserves the familiar idea that legal norms are general and prospective, while carving out a limited space for law's defeasibility, which he grounds in the value of coherence. Professor Bayón's impressive array of intellectual interests extend far beyond the debates in legal theory. He has written on the economic analysis of law, he has waded into the debate on constitutional theory, and he talks about political theory more generally. For instance, he has cast a critical eye on the central claims forwarded by key figures in the area of economic analysis of law. Here, he takes aim at the familiar thesis that private law should be exclusively concerned with attaining efficiency. He has also entered the debate about the normative foundations for judicial review. Here, he stakes out a limited version of weak constitutionalism. Most recently, Professor Bayón has turned his philosophical gaze to the myriad of questions surrounding the relationship between democracy and our global order. Specifically, he challenges the view that democracy can thrive beyond the borders of the modern nation-state. He persuasively argues that the connection between democracy and sovereign authority is not merely a contingent one. Now, without further delay, I'd like to turn the floor over to Professor Bayón. He will present his paper entitled The Province of Jurisprudence Undetermined.
Thank you. Yes. Thank you. First of all, of course, I'm very grateful to the organizers of this conference for having invited me to take part on it, and also for their warm hospitality. And of course, I am also very grateful to Margaret Martin for her kind words, and to you all for being here. Unfortunately, I'm not as fluent in English as I would like to be, and so what I'm going to do in this presentation is to read out my text, the text you have. By the way, in the text you have, there are some linguistic errors and perhaps several theoretical mistakes, but this is an entirely different thing. There are some linguistic errors, and I apologize for that, of course. Perhaps, if necessary, in order to be in time, I will skip some little parts of the text, but for the rest, I am to read it out. To be sure, jurisprudence or legal theory can be, and is in fact, conceived of and carried on in a number of different ways. John Austin famously claimed that in order to pick out the proper subject of jurisprudence, that is, to determine its province, what has to be ascertained is the essence or nature which is common to all laws that are laws properly so called. So, jurisprudence, as conceived of by Austin, is descriptive and general. It is descriptive in that its task is to provide an account of what law is, which amounts to grasping its essence or nature, something that, according to him, may be found out without asking what a legal order morally ought to be. And it is general in that it is an inquiry into the nature of any legal system properly so called, and so unconcerned about the parochial and therefore contingent or inessential features of any particular practice that is to count as a legal order. Measured from the vantage point of current philosophy, Austin's methodological stance was surely naive and unrefined. And besides that, after heart, it is conventional wisdom that his substantive views regarding what has to be deemed the essence or nature of law are seriously flawed anyway. Still, what has proved to be rather lasting in mainstream analytical jurisprudence is the very idea that building a theory of law is a descriptive and general endeavor whose aim is to identify the nature of law, that is, the necessary or essential properties that something has to have in order to count as law. The basic assumption that this is the proper way of understanding the aim and purpose of jurisprudence can be found among the most prominent contemporary theorists in the legal positivist tradition, even if it is now rooted in sophisticated philosophical frameworks, very far away from Austin's methodological simple-mindedness, and whatever they be the precise contours of the substantive theories of law which turn out to be sustained in each case. Thus, Hart famously claimed to have elucidated two minimum conditions necessary and sufficient for the existence of a legal system, and held that the union of primary and secondary rules may be justly regarded as the essence of law. In quite the same vein, Ras contends that, unlike the sociology of law, a philosophical theory of law is concerned with the necessary and universal, so that it has to be content with those few features which all legal systems necessarily possess. And also, Coleman has said that the descriptive project of jurisprudence is to identify the essential or necessary features of our concept of law. However, it is well known that over the last 2 or 3 decades, the idea of a general jurisprudence as a purely descriptive enterprise aiming at elucidating the nature of law through conceptual analysis has been challenged from different fronts. So different, in fact, that it is distracting to characterize the current discussions as opposing proponents of a descriptive jurisprudence on the one hand against those that hold that jurisprudence has to be normative on the other. In the context of the discussion about the methodology of jurisprudence, both descriptive jurisprudence and normative jurisprudence turn out to be crude and potentially misleading labels which mistakenly suggest that there is a single divide between two clearly defined and internally homogeneous positions, which is not the case, that are at any rate antagonistic, which, depending on the way these labels are understood, need not be the case. Just to give a compressed and very simplified sketch of the different positions which are upheld in the current debates about the methodology of jurisprudence, let me notice to begin that at least 4 different senses should be distinguished in which the idea of a descriptive jurisprudence may be understood and vindicated. The simpler one, too simple and naive, indeed, has it that the nature of law, its defining features, can be grasped just by looking at the world as it is, a task for which no value judgment of any kind would be needed. But this is a view that simply fails to realize the complexities involved in categorizing the data. For instance, we broadly assumed that an inquiry into what law is, which is an inquiry into the concept law, involves nothing more than seeing what is common to all the items to refer to which the word law is or has been used. Jurisprudence would be unable to offer us but a lowest common denominator deprived of any explanatory value. A second and more refined view, which prevails today among positivist legal theorists, holds that to be explanatorily adequate, a theory of law cannot be entirely value-free, in that it has to resort to value judgments to select what is significant about law and then pertains to its nature. But according to this view, the fact that some kind of evaluation is required for jurisprudence to perform its task does not mean that it has to be morally evaluative, because the theorist does not have to take a moral or justificatory stance about the worth or value of law to understand its nature. Thus, even if it is admitted that jurisprudence is evaluative, it is conceived of, in any case, as a project that can be carried on without endorsing any substantive moral claim or purporting to justify anything. Julie Dixon has coined the expression indirectly evaluative to convey the idea that jurisprudence has somehow to be evaluative without being morally evaluative, and we may follow her and adopt it as a helpful way of referring to this view. And the main point here is that insofar as indirectly evaluative jurisprudence is morally neutral, it would make sense to keep on considering it as basically descriptive. By the way, this is not the opinion of Dixon herself. She says that it's rather a misnomer. It's misleading to say that this kind of jurisprudence is descriptive. But I think instead of that, we can say that it's basically descriptive, meaning that it's morally neutral. Even if, in a sense, it's an evaluative or norm-governed enterprise. A third view contends that legal theory has to be descriptive in an utterly different sense. According to this view, legal theory should take seriously the lesson to be drawn from Quine's critique of the analytic-synthetic distinction, which would imply to put into question the fruitfulness of a priori conceptual analysis, and thus the very idea of law having a nature or any essential properties, so that some propositions about it were necessarily true or true by definition. Hence, we should proceed instead to a naturalistic turn, so that jurisprudence should be absorbed into social science, and the answer to the question of what law is should emerge from an empirical inquiry as the one with the greatest explanatory and predictive power. Of course, Brian Leiter is the person who has defended more forcefully this point of view. And finally, in a fourth and substantially different sense, it is still possible to ground the claim that jurisprudence is descriptive in some specific positions in metaphysics and the philosophy of language, whose applicability to the law is highly questionable, and that most legal theorists today would be reluctant to accept. It is the case, for example, of Michael Moore's views about how the theory of law is to be constructed, which require to assume that law is a functional kind, in a sense akin to the notion of a natural kind, so that ascertaining the nature of law would be something of an analog to scientists' discovery of the nature of the sort of things natural kind terms refer to. The idea of a normative jurisprudence, on the other hand, is likewise understood in different ways. The first one, that has been sometimes called the Benthamite project, this is for instance Coleman's label for it, or the beneficial moral consequences argument, this is Dixon's label, is in fact a prescriptive theory of the concept of law, in the sense that its aim is to recommend what our concept of law should be or should become in view of the moral consequences that would follow from embracing it. As such, this approach needs not to deny the possibility of a descriptive jurisprudence. That is, it needs not deny that we can get a successful explanation of our concept of law as it is without making any moral commitment. And in particular, it needs not to sustain the fallacious argument that the beneficial moral consequences of a certain concept of law support the conclusion that this actually is our concept of law. The enterprise that the Benthamite project would be pursuing is simply different and not necessarily antagonistic to the idea of a descriptive, that is, morally neutral theory of law. We get at a second sense of the idea of a normative jurisprudence, which is seemingly related to the former one, but in fact different from it. When it's endorsed the claim that there simply may not be a single concept of law we all share, that there rather are different concepts of law, or in other words, that our concept of law is to a significant extent indeterminate. Well, if you find that it is inaccurate to say that a concept is indeterminate, if you prefer, we can say law, the term law is ambiguous among different meanings corresponding to different concepts. In this case, there is leeway to decide to adopt one or other view of law, or to refine in a definite direction the partly indeterminate concept of law, on the basis of moral and political reasons. And this is precisely what jurisprudence would have to do. This is what has been called the engineering or legislative project. This is Coleman's label, or the practical political argument, Dixon's label. Both this view and the former one, the Benthamite project, have been at times associated with what has come to be, to my view, confusingly called normative positivism, which, as it is usually presented, is, by my lights, more a cluster of logically independent theses than a single and well-defined theoretical position. As far as I can see, normative positivism, or ethical positivism, or prescriptive positivism, is primarily a substantive normative view about how legislation ought to be formulated and how it to be interpreted and applied by the judiciary. But under the rubric normative positivism, one may sometimes also find specific jurisprudential claims about the content of the concept of law and the nature, descriptive or otherwise, of legal theory. Claims that it turns out to be, most of the times, are in the line either of the Benthamite project or of the engineering or practical political argument. Thus, because of these ambiguities, I think that in the context of the present discussion, it's better to avoid using the rubric normative positivism altogether. And finally, there is a third, much stronger sense in which it has been said that jurisprudence is, and has to be indeed, normative. This is the sense embraced by any view, as for instance, although in very different ways, views like those of Finnis or Dworkin, according to which an analysis of the concept of law requires engaging in substantive moral or political argument, so that one has somehow to rely on moral judgments in order to give a proper account of what law is. Thus, unlike the engineering or practical political argument, what is contended now is, first, that there is indeed a definite concept of law, and that the proper subject of jurisprudence is to get it right, not to propose a way of shaping the concept attending to moral and political considerations. And second, that we simply cannot get it right without understanding the point of law, which would purportedly require endorsing substantive judgments of political morality about law's worth or purpose. In other words, a proper understanding of what law is should be grounded on an adequate understanding of law's morally valuable purpose or point, with the result of making conceptual analysis of law a part of moral or political philosophy. There is at present a growing literature about a methodology of jurisprudence, so that one can even say that in recent years analytical legal theory is, to a large extent, turning its attention from substantive or first-order questions to methodological or second-order ones, or as Alexei has helpfully put it, from debating the nature of law to debating the nature of arguments about the nature of law. It's not my purpose here to offer a comprehensive overview of the current debate about the methodology of jurisprudence, nor to engage in full discussion with each of the views I have briefly outlined. I will merely intend to pick out some salient points instead. First, I shall take issue with the idea, which seems to me to be mainstream among positivist legal theorists today, that jurisprudence is best conceived of as a general and basically descriptive enterprise, whose aim is to adequately explain the nature of law through conceptual analysis, and that in order to accomplish this task cannot be entirely value-free, but needs only be indirectly evaluative. And after that, I shall suggest that jurisprudence should be normative in the second of the three senses previously distinguished, that which have been called the engineering or practical political argument, or we can say perhaps Liam Murphy's argument, having been him the perhaps main defender of this point of view. None of these arguments, as I shall put them forward, is entirely novel, nor do I claim they are. But I shall intend to show that some important points about them may be perhaps more sharply put, and especially that some standard objections to the thesis I shall endorse might be cleared up. Thus, let me recall the mainstream view held by analytic jurisprudence in the legal positivist tradition, which Stephen Perry has helpfully called the methodology of necessary features. According to it, the aim of jurisprudence is to give us an adequate explanation of the nature of law, and any claim about the nature of law is a claim about what law necessarily is. This entails that there is a set of features that law necessarily possesses, so that if a legal theory is successful insofar as it identifies this set, the features that something has to exhibit in order to be law, then the propositions that make up such a theory are necessarily true. However, it should be clear that, leaving aside the case of natural kinds, the world as it is does not come demarcated in kinds. Our concepts set their boundaries. Hence, an explanation of the nature of law, of what law is an explanation of the concept of law. Moreover, as the concept of law, any concept indeed, is a changing historical product, what legal theory should identify, according to this view, are the necessary features of our concept of law. In this way, it said, it contributes to our self-understanding. But in order to do that, it has to highlight what is really significant for us. And then, among the necessary features of our concept of law, it has to select the subset of those which also are interesting or important. Then this program has to face, to my mind, two significant problems. In the first place, it seems that in order to pick out the features that law necessarily possesses, we should previously know what counts or does not count as law. But this depends in its turn on what features are deemed necessary to count as law. The second problem is that we should make clear how are we to determine which features are important. Let me elaborate a bit on the first of these problems. The difficulty lies in determining what belongs or does not belong to the set of things we are trying to explain, given that the theorist must be examining law and not anything else, and everything that counts as law if his or her claim is to provide a general account of it. It could be said that this is not a problem at all, and that the mere fact of having thought otherwise reveals a deep misunderstanding of how conceptual analysis proceeds. Once we realize that what we are trying to identify are the necessary features of our concept of law, we would simply have to rely on our pre-theoretical shared understanding of the concept. And this would be all we need at the beginning to set a standard by which we could determine what counts as law. As Hart said, the starting point, and I quote Hart, the starting point for this clarificatory task is the widespread common knowledge of the salient features of a modern municipal legal system that any educated person has. But now we have to ask, as Stephen Perry does, who is this we? Who are those that have an agreed upon shared understanding of the concept of law? Among legal theorists, at least, it could hardly be said that there is agreement about which are the features that something has to exhibit in order to be law, the features that law necessarily possesses. It has been sustained both that every legal system is necessarily coercive, and also that resort to sanctions is not a necessary feature of our concept of law. That it is implicit in our concept of law that every legal system claims to possess legitimate authority, and also that there is no convincing reason to suppose that the gunman situation writ large could in certain circumstances be considered law, and, to the contrary, that a purely arbitrary power which violates the principles of the rule of law altogether cannot be called a legal system. That a claim to supremacy is essential to the law, and also that this does not have necessarily to be so. And of course, it remains contested whether extremely unjust law would still be law, and it also remains contested whether it is conceptually possible to incorporate morality to law or not. But the real trouble is not disagreement among theorists. The real problem is that inasmuch as members of society also have partly different and in any case blurry pre-theoretical understandings of what counts as law, it seems that legal theorists will have nowhere to look to in order to resolve in a non-question begging way their disagreements about what features law necessarily possesses. Every time it is claimed that something is a necessary feature of law, and it is replied that we can conceive of systems of law where this feature is lacking, there are two possible reactions. Either accepting that the claim was mistaken, or else retorting that the purported counterexample could not be properly called law. But if there is not a single concept of law we all share, but rather partly different concepts, there seems to be no principled way to decide which one of those reactions should be deemed appropriate in each case. Supporting one of these reactions or the other by giving an argument about what is the nature of law would simply be question begging, when different people consider different things to count as law, just because they have different concepts of law. Two possible objections may be raised against this view. The first one would say, on the one hand, that it overstates the reach and depth of disagreement which actually exists about the concept of law, and on the other hand, that even if there is at the margins a certain extent of disagreement about its content, that is exactly what we can expect of any philosophically interesting concept. But I think that the objection can be met. To be sure, it has to be considered that if we have different concepts of law, they overlap to a great extent. Otherwise, whenever we talk about law, we would be talking past one another. But this overlap is not the same that there being a single concept of law, and it does not exclude that a number of interesting questions about the boundaries between law and non-law will remain, for which we simply won't be able to find an answer in any shared understanding. Besides, if the aim of legal theory is to uncover what is necessary and important about law, a search for the features which all the different and overlapping concepts of law coincide in considering necessary would make us to lose sight of much of what is important from the point of view of each one of them. The second objection would go deeper. It would say that the contention that we have different concepts of law is the product of a dubious semantics. In fact, it would be the product of having endorsed criterialism in a Dworkinian sense. As it is well known, Dworkin holds that that what he calls the sociological concept of law, namely our concept of law as a certain type of institutional social structure, is criterial. That is, the kind of concept we can say we share only on condition that we agree on a set of criteria for the correct application of the corresponding concept word. Then, the sociological concept of law is simply imprecise, because there is no full agreement about these criteria. And therefore, all we can do is to report this imprecision and to acknowledge that it is not the kind of concept whose analysis can yield philosophically interesting, essential, or necessary features. And, at most and eventually, for some purposes, such as social science investigation, to stipulate a more precise definition. But then, if criterialism, or Dworkin's account of it, is flawed as a theory of how the extension of a noun is determined, and if the idea that there is not a single concept of law we all share, but rather partly different concepts, were a result of having assumed criterialism, then this idea, the idea that there are partly different concepts, would now be lacking any serious support. This is not the place to engage in full discussion about criterialism, the right way of understanding criterialism, or the alternatives to it. Suffice it to say that, to my mind, the idea that there is not a single concept of law we all share does not depend on accepting that for individuals as speakers to share the meaning of a concept words amounts to having propositional knowledge of a same extension-fixing set of criteria. We may think instead, as for instance Raz has said, that these criteria need not be completely transparent for the people who share them, and even that we can distinguish between ordinary and theoretical explanations, so that the theorist can somewhat redraw the boundaries of the concept as compared with what would superfluously result from the data of actual usage by ordinary speakers. Or we may also think that for individuals to share the same concept, all that is needed is agreement on paradigmatic cases of instances of the concept, and not on a set of criteria of application, because the ability to classify is practical, and then the beliefs required to fix the extension of a kind term are basically de re and not de dicto. But nothing of this, however, seems to me to be enough to rule out the possibility that there be partly different concepts and not a single concept of law we all share. One can grant that sharing the same concept does not imply sharing the same application criteria, and even less being able to formulate this set of criteria and doing it in the same way. But this could hardly assure that we do share a given concept, as for instance the concept of law. If there is not a single concept of law we all share, but rather partly different concepts, the enterprise of picking out the necessary features of our concept of law cannot be carried on. Thus, the province of jurisprudence, the objective to be pursued in theorizing about the nature of law, seems to be left rather underdetermined, given the variety of available perspectives. But were this not enough, we still have the problem of how to establish which features of law are significant, interesting, or important. What is at stake here is the very possibility of determining what is important in the way that the project of an indirectly evaluative legal theory purports it can be done. Then we need to make clear by what standards could be determined whether something is important or not, and therefore how are we to decide among competing judgments of importance. The minimal sense in which it's widely admitted that legal theory, or any theory indeed, cannot be entirely value-free has to do with the truth, the banal truth, that theorizing ought to fulfill some epistemic or meta-theoretical requirements, such as simplicity, comprehensiveness, coherence, and so on. But it is doubtful whether these meta-theoretical values alone can settle the question of what is important. On the contrary, it seems to me that we need to know in the first place what is important in order to test whether some of these requirements are satisfied or not. For instance, an explanation would not be simple enough if it includes something unimportant, or it would be not truly comprehensive if it fails to include something that is important. Thus, according to Dixon, legal theory has in fact to resort to something beyond epistemic or meta-theoretical values in order to determine what is important. She calls indirectly evaluative propositions, those of the form X is an important feature of the law. And she thinks that propositions of this type may find support in different kinds of considerations. Some of these considerations are, in my view, hardly useful. To wit, that X is a feature which law invariably exhibits, or that something is important on the basis of the prevalence of certain beliefs concerning that feature on the part of those subject to the law. And these two considerations are to me hardly useful because if there is not a single concept of law we all share, and therefore no correct account of the nature of law, then there is disagreement about which features the law invariably exhibits. Likewise, there will be disagreement among those subject to the law about what is important. If the legal theorist has to do something more than merely reporting those disagreements, it's not entirely clear upon which basis he or she is expected to do it. Especially when, as Dixon does, it is said that some self-understandings of the participants will be confused, and some will be more important and significant than others. One cannot rely solely on the fact that the belief that something is important prevails among the participants to support the claim that it is, in fact, important. The main support such a kind of claim can find in Dixon's account comes from a different source. According to her, a proposition of the form X is important, even if it does not entail propositions stating that X is good or bad, may nevertheless be supported by the fact that it is a matter of practical concern to us whether a social institution that exhibits X is a good or a bad thing. But as far as I can see, it's difficult to understand why the fact that something exhibits the feature X should be a matter of practical concern for me, unless I think that X is or can be either a good or a bad thing, either something to hope for or something to fear. So I think it's one thing to say that considering that X is important is not in itself an ascription of goodness to that X. This seems to me to be right, and quite another to conclude that it's possible to identify what is important about law without making any substantive moral claim whatsoever, so to speak, in a vacuum of moral and political theoretical assumptions. If it is accepted that there simply may not be a single concept of law we all share, that there rather are different concepts of law, and that claims of importance have to be grounded on moral and political considerations, jurisprudence should, to my mind, be reconceived as a different enterprise. In the line, I think, of what has been called the engineering or legislative project, or the practical political argument. By now, it should be clear, I think, that this does not amount to indulging in a form of wishful thinking, confusing a proposal about how it would be better to shape the concept of law with the right account of the concept of law we have. I think that there is here not the confusion some people have denounced sometimes among what law is and what we would like law to be. I think there is not this kind of confusion. And there is not this confusion because what is denied to begin is that there is a single concept of law that we all share and that legal theory has to get right. In fact, if there is a hurdle to overcome before accepting the pertinence of this kind of project, it probably lies elsewhere. And I would like, just to conclude, to comment very briefly on this. The problem is that the engineering project seems to presuppose that we can ascertain what social and political what social and political consequences will produce general convergence on a particular conception of what law is, and presuppose as well that these consequences will be different were we to converge on a different conception. And perhaps none of these assumptions can be granted. Perhaps it is uncertain what consequences will ensue, and maybe these consequences will be the same, whatever conception is adopted. If the kind of consequences we have in mind have mainly to do with people's critical or uncritical attitudes toward law, as in the classical Hart-Fowler debate, then the doubts are probably founded. But things are different if the issue is considered from another point of view, the one that has to do with the relationship between the questions what is law and what is the law of a particular community at a given moment. It is a standard positivist criticism of Dworkin that he confuses these questions, and in fact they are different. But their being different does not imply, to my mind, that the way we answer the first one has no bearing at all on how we are going to answer the last one. Coleman and Simchen, well, I'm sorry, I really don't know how to pronounce this name. Simchen have pointed out, I apologize for that, have pointed out that it is possible to disagree about extension fixing criteria for law without having to disagree about the claim that a certain proposition about the law of our community is true or false. And I think this is right. But this does not preclude the possibility of disagreeing about a claim of the last kind precisely because we disagree about the extension fixing criteria for law in the first place. We implicitly use, I think, a concept of law every time we state the content of the law. And then if our concept of law is partly indeterminate, or better, if we have different concepts of law, it makes sense, to my mind, to advocate for shaping the concept of law in a certain way in the light of the moral or political value one believes their consequences on legal practice would have. Thank you.
We have just about an hour for questions. I'll take the first one here. Scott Shapiro.
Hello? Yeah. Thank you. That was a really interesting paper. The argument for the engineering concept, it seems, is based on the view or the argument that, in fact, we don't share the same concept of law, and so therefore the project of conceptual analysis doesn't have an object. Now, the evidence for that claim is the fact that there's disagreement among theorists about what the concept of law is. Now, it seems to me that that's not very strong evidence at all for the view that we don't all share the same concept, because, well, if conceptual analysis is an attempt to provide an analysis of something, an explanation of something, one would expect there to be disagreement about what the thing is. So rather than impugning conceptual analysis, it would actually support the idea that there's some substantive activity going on. So if scientists have different theories about some phenomenon and they differ, you wouldn't say, oh, they're arguing about different things. You would be saying, no, that they are arguing about the same thing, just giving different explanations. And this would be true even if one scientist were to say to the other, the reason why your theory is mistaken is because the data you're using is corrupt, which is what happens all the time in conceptual analysis when people say, you know, you have the wrong intuitions. So I just actually don't see, I mean, it's possible we don't share the same concept, but it's also possible that we do. We're just actually having a real disagreement.
Yeah, I think yours is a very well taken point. Perhaps all that amounts to something like who has the burden of proof, in a sense. You say, what is the evidence to support that we don't share the same concept? It's weak evidence, the fact that theorists disagree, because theorists are trying to provide explanations, and perhaps theorists provide sometimes very bad explanations, but that's not proof that we don't share a concept of law. Is that your point? Yeah? Yeah. Well, but I think this disagreement about theorists must be significant, must be taken seriously, because it would be rather apparent that some of them are mistaken if we intuitively would recognize something, some of these explanations are of the point. But I think that first, lay people don't have very definite concepts about law. They recognize, as Hart said, what is a municipal legal system as the one we have, in a very blurry and fuzzy way. But confronted with the question, and this other kind of system that differs of ours in this or that feature would also be a legal system. I think people, first, perhaps doesn't have any clear idea about that, and if were they to pronounce a certain opinion in one or another sense, perhaps it would be a disagreement. In the last resort, this is not but an empirical question. This is an empirical question, if this situation of sharing or not sharing a concept of law is in fact true. What have interested me most is to say that there is, to my mind, no master conceptual argument to rule out the possibility of disagreement about what is our concept of law. I think there is no key master argument. If, in fact, we share or not the same concept is an empirical question. And the matter is what kind of evidence we can count upon to say that the situation is one or another. You say difference among theorists are not in any way conclusive. I think they are significant. They are significant because otherwise it would be very strange a situation. I think that concerning other social concepts, there is not this kind of essential disagreement among theorists. Either theorists think that the disagreement is trivial, there are different senses and there's nothing more to do than reporting this kind of disagreement, or the degree of disagreement is not so huge. So to my mind, theoretical disagreement has to be taken as a clue.
Hello? Hello?
Just name any philosophical concept, and you're going to get great disagreement.
What? Hello? Okay, thank you. Okay. Any philosophical any concept for which there's philosophical disagreement, which is like any, knowledge, truth, action, science, art. I mean, anything. You're just going to get huge disagreement. I mean, that's why we have a job. And so you don't want to infer from that, I don't think, that therefore we share none of those concepts. If we actually if we didn't disagree, then we'd move on to something else. Anyway, but thank you anyway. That was very helpful.
Yeah, but again, I think it's a difference between between some of the concepts you have talked about. For instance, what is science, or what? For some concepts, perhaps there is some linguistic division of labor, and what is science or what is physical reality or something like that is a matter for experts to determine. More or less in the sense that what is really water or gold, to use the well-known examples, is a matter for science to decide. And ordinary people, in a sense, has to defer to what science are saying about that. The concept law, to me, is different. I think that there is no such kind of division of linguistic labor with the concept of law, which is ingrained in people's life in a different sense. So there is controversy about what action, science, responsibility, and all that means, but the difference about the concept of law is a concept with which first we need not to defer to the opinion of experts, and second, it's a concept in relation with which, in a certain sense, is unsatisfying to say simply, we have different concepts and that's all. Because there are practical questions immediately related to what is the proper concept of law. And these immediate questions has to do with the consequences on the determination not of what law is, but of what the law is. And so we need to choose among different concepts and refine these different concepts in a certain way. And this needs does not rises in the same sense in other enterprises concerning other concepts. We can leave our disagreement about science or sense, but the link between the conceptual enterprise in concerning law and the practical matters, I think, forces us to this choosing and refining. But in the fact, I concede that one critic could say, well, the existence of different concepts, or the fact that we all don't share a single concept, is more assumed, in your view, than proved. Well, in a certain sense, this is right. And the value of theoretical disagreements as a clue to sustain this claim perhaps is not definitive, but I think counts for something. I think. Oh.
On? All right.
Sorry, another one. No.
It's just not going to work when I do it. Okay. I'm Jules Coleman. I know Scott. I just want to follow up on Scott's question. I agree, obviously, since you cite me as a source for this, with the view that law is a concept that in order to fix its extension, we don't have to rely upon theorists. So the fact that this theoretical disagreement is not going to be pertinent to our capacity to make judgments that are capable of being true or false about law, ordinary people, capacity to do so. All right? So the existence of theoretical disagreement about the criteria is not relevant to our capacity for ordinary folk to fix its extension and make assertions about it, right? Okay, so then theoretical disagreement doesn't bear on the question about, it's not pertinent to the existence of our ordinary folks' capacity to make judgments about the nature of law and about making claims about something being true or false. So that argument seems to me to be gone now. That is, you said it's significant, but it's not significant to the central burden that ordinary folks face. So it is significant with regard to the question of what the theory is about what was the correct theory about something. But that's just true of every discipline, right? Among theorists, disagreement about the nature of knowledge, disagreement about the nature of truth, disagreement about the nature of art, disagreement about the nature of philosophy. All right. So that disagreement exists, but it's not of special interest or importance, if I'm right, along with Simkin, about fixing the extension. And I'm sure I am. I'm sure he is, in any case. All right. So, so then I thought you introduced a second argument now in response to Scott, which was of the sort that judgments about what the law is are of such practical significance to our life that we have to agree about what the concept is. But judgments about what truth is and that assertions about something being true are so significant to our ordinary life. Judgments about knowing that such and such is the case are so significant to our ordinary life. Judgments about what science is are not necessarily significant to our ordinary life, but just judgments about justification, truth, knowledge, and so on are so significant to our ordinary life that it would seem to suggest that you are then committed to the view that we have to share the criteria with regard to them, but we don't. So I'm kind of puzzled as to what the actual structure of the argument is. The starting argument was this theoretical disagreement. Theoretical disagreement turns out not to be significant with regard to the capacity of ordinary folks to fix the extension of the terms. Now, theoretical, but that doesn't mean that ordinary folks share the criteria. Then we can agree on that, because to fix the extension, you don't have to fix the criteria. You don't have to share the criteria. So sharing the concept doesn't involve sharing the criteria. So now what matters is the fact that people must share the criteria because it matters so much in their ordinary life. That disagreement about what the criteria are is significant because these judgments about what the law is or something like that matter so much in ordinary life. But judgments about truth, that such and such assertion is true, matter in people's ordinary lives. That such and such so-and-so has knowledge of the truth of something certainly matters in court, and so on. So I'm just a little puzzled as to the relevance of the fact that something matters significantly in people's practical lives, why that would have an impact on making theoretical disagreement or disagreement about what the criteria are important.
Well, as far as I can see, there are two main points or questions. Well, the first one is theoretical disagreement is irrelevant once we accept that to share a concept we don't need to share an explanation. And is this the point? Yeah. Well, but then what is relevant to test if we share a concept or not I consider it's not the ability to provide this set of criteria to have propositional knowledge of that, of them, and so on. But what is important then is intuitive responses, intuitive answers to where there is a case of that, something like that. I have a paradigmatic case, and we are confronted with other cases, and I have to decide in what senses that is like our paradigm or not. I have to implicitly have a sense, an intuitive sense of that this is like that. This is the question. But I think the intuitions about what would be law are manifold among the people. These intuitions does not coincide. And then we can move on the intuitive answers of ordinary people and not to explanations by theorists. And at the level of intuitive answers by ordinary people, I'm not sure at all that there is something like agreement on a concept we all share, because intuitive answers are surely different and very various, I think. So at this level, and I insist, it's an empirical question if this is like that or not. But one can reconstruct the presentation of the idea that we don't share the same concept at this level. If what counts are intuitive answers to what is like the paradigm or not in the relevant sense, I think that at this level there is disagreement. And concerning importance and so on, practical relevance of this concept, well, I think that what we can do, and perhaps what we should do, is to take this situation of different concepts being in place as an opportunity in the moral and political sense to try to conduct the practice in a different sense that is guided by political, moral judgments. One can say where the situation is not we all sharing the same concept, but there are being different concepts in place, it does matter which of these concepts is to prevail in the minds of judges, in the minds of law professors who inform law students, and in the legal culture, so to speak. And I think we can take this situation as an opportunity to guide in a certain sense. Of course, the idea that we can take this as an opportunity depends on supposing that the consequences could be different, whether we opt for one certain shaping of the concept of or another. If the consequences are in any case, or will be probably in any case the same, well, the project is dead. But I think it's not, because different conceptions about what law is. What law is, perhaps in two different senses, which maybe are not clearly separated in the paper, and perhaps we should that clearer. What law is as a social institutional structure, to use Dworkin's labels, the sociological concept of law, and both what law is in the sense of which the criteria of legality are, Dworkin's doctrinal concept. No? If in both these senses we disagree, and if we can take this situation of disagreement as an opportunity to take a certain line and not another upon political, moral considerations. I think this is an important task for jurisprudence to do, and I think more important than a search for necessary features of our concept of law that, in a certain sense, seems to me doomed to failure. I think this is an enterprise, for me, is doomed to failure. So what I'm suggesting is, in a certain sense, let's talk about different things. Let's change conversation. Not about which are the necessary features, because that presupposes there is one concept with necessary features, necessary and important, with the problem that knowing what is important and why is more an invitation to take a different way. But I don't know if this is sufficient as an answer. It's probably not.
The third question will be at the front here.
Yes, thank you very much. My question is divided. Is divided into two parts. The first part of my question concerns the concept of a concept. I have the impression that you use a conventional conception of the concept. The concept as Lewis or Carnap, the concept of a kind of social rule concerning the meaning of a word. Then I think we must say different people have different concepts. But our concepts and I agree with you, concepts are first and foremost social rules of a special kind. But I think that is not enough to explain the nature of a concept. Concepts, persons who use a concept raise the claim, I think, that their concept is adequate or correct. With this, concepts include the claim that it is adequate to what it refers to. And with this, we cannot, and once we agree with this, from the point on we agree with this, the concepts, the different concepts, the difference of concepts as a social fact, the different concept of different people became related to each other. For then we have not only to describe the disagreement of concepts, the use of concept, but from this moment on, it becomes sensible to engage in a debate about the correctness of the concept. That is my first point. And now, much more important, my second point concerns, connected with this, concerns your concept of an indirectly evaluative. Indirect evaluative. I think it is not easy to understand this. There is one explanation which is rather easy. That would be the explanation something is indirectly evaluative, X is indirectly evaluative, if X is descriptively evaluative. And I suppose that that is the meaning in which you use the concept of indirectly evaluative. And then it means that you describe, descriptively evaluative, you describe the evaluations other people make. As an observer, you describe the evaluations the participants of a legal system have. Then I understand your concept of indirectly evaluative very good. But if you use the concept in this sense, that is, indirectly evaluative is the same as descriptively evaluative. From that moment on, you cannot any longer engage in a debate about which concept is correct. At least not on the evaluative basis, on the basis of the evaluations those people have you describe. Then you can, as an observer, naturally engage in a debate about the concept, whether it is fruitful from a descriptive point of view. But that are other criteria. Then those people apply to the concept of law which participate in a legal debate in a legal system. And therefore, I think the most important, it is much, I think the basis would be to ask from the point of view of the participants what is the correct concept. And therefore, my question now is, how do you distribute? How do you distribute the evaluativeness in your concept of indirectly evaluative? It is mainly from the point of view of the observer or of the participant? That is my question.
Oh, thank you. I begin with your second point. Well, I should make clear that it's not my concept of indirectly evaluative, but Dixon's concept. And the purpose in my paper was to criticize this notion that is not my conception. So, in a sense, I think what you have said is in full agreement with my point. Because what Dixon says is, in which sense jurisprudence can be merely indirectly evaluative. And he says, first, the proposition X is important may be grounded in the fact that X is a feature that law always exhibits. But this is question begging, because well, which are the features the concept of law invariably exhibits? Second, descriptive description of the evaluation other people is doing. X is important, may be grounded on the fact that those subject to the law, participants, see X as important, are seeing X as important. But here we need only to recall Hartian saying that description is still description, even if what is one describing is evaluations made by other people. So I don't see in which sense this would be really evaluative in any sense at all. It is merely description of the evaluations participants are doing. Even more, if, as Dixon, not me, says, we can contend that some of the views of participants are confused. I really don't mean I really don't know what does it mean to say that some of the views of participants are confused. But it's her point. It's some of their views are confused, and so the theorist must filter, must select among the point of views which are upheld by participants. Which one of them are more significant? In this case is utterly evaluative, not indirectly, but utterly evaluative. If I report the evaluations made by participants, it's not evaluative at all, nor indirectly, nor in any other sense. On the other hand, if I pick up what or which among this point of view are confusing, which are more important, then I am doing full evaluation, not indirectly. So, for me, the dilemma for Dixon is either is not evaluative at all, nor indirectly, nor in any other sense, or it is fully evaluative, nor indirectly evaluative. So in this sense, I think that according to me, on the second of your points, I really not disagree from what you have said. I think rather that both of us disagree with Dixon. I think this is the point. Concerning the first point, what concept of concept we have, and mine is broadly said conventional. Well, yes, I think. I don't quite understand your idea of concept being correct or not correct in anything that has not to do with conventional facts and practice. Concepts are changing. Our concept of law need not be the same as the concept of law in other cultures or in other times. And so the question, but which is the correct concept? I don't know what to say about this question, except if perhaps one thinks that law is something like a natural kind or something like this. In this case, science has to make clear what is really gold or water or anything like that. And there is a correct understanding of the concept that fixes the extension of the norm, and beliefs of ordinary people about what is gold or what is water may be confused, etc. But all that holds for natural kind concepts. Leaving aside this special case, in the case of artifactual concepts like law, well, perhaps Michael Moore's views are different and some other people's views are different, but I think there is agreement, general agreement, that we cannot take law as a natural kind. And if it's not, I really don't grasp in what sense, completely outside of what is conventional, one could speak about correct concepts. I don't grasp this idea. In what sense one of these concepts is correct or not correct?
Our next question is over here. Right at the front here.
May I?
I think you're next here.
It's me?
Sorry.
Thank you very much. My name is Carlos Bernal, and I would like to ask you about an assumption that I think is implicit in your answer to Professor Alexia and to Professor Shapiro, and also I think it's in the page 10, and is your skepticism about the possibility of stating the necessary properties of non-natural kind objects. And I would like to ask you about your evidence for that. I'm sure, for instance, that the law is very different to water. But for instance, I don't believe that you have presented us a strong evidence that it is impossible to find out the necessary properties of non-natural kinds, that is to say, the properties that they should bear in all possible worlds in order to be what they are and different to other things. Let me give you an example. For instance, I know that we have here many Argentinian colleagues, and dancing a tango is a social practice as the law. And maybe when people engage in social practices like dancing a tango, they have some common knowledge between them, so that they know when they are dancing a tango and know other things. And a participant in a practice like this have this common knowledge. And also an observer of this practice, they have this common law. The observers of this practice, they have the knowledge about what the necessary properties of dancing a tango is. Maybe an Argentinian person can tell you when two people are actually dancing a tango or dancing another thing, or not dancing at all. Then, if this example is sound, then maybe with the law we could say that something alike is going on. Legal officials and citizens adjudicating and following rules. They have some common knowledge about some properties that are essential for the law to be in every possible world. And also observers, it could be the case that also observers could identify these properties for the law in every possible world.
Well, first, to speak of law in every possible world sounds to me rather strange, but surely are possible worlds with no law, I think. So law in every possible world would has law. But besides that, well, it depends on how one is picking up examples or counter-examples. Perhaps what counts as tango or what counts as chess, to play chess, is not contested. I think people who plays chess knows what is the concept of what counts as playing chess. And there is no disagreement about that. But think of other practices. I think that law is a very different kind as a practice from tango or chess, or it is contested. It's different at the core of the example you have picked up. And so, the fact that for some concepts, as what counts as tango or what counts as chess, we perhaps could conduct an analysis in terms of necessary conditions, necessary features, I think does not prove that for other kind of concepts that are of, for me, of an entirely different nature, because they are contested practices. They are practices with different views among the participants about what we are doing, what is important, what. So your point has picked up an example that I think is loaded with the presuppositions that we can afford an analysis in terms of necessary conditions. But my answer would be the law is a different practice. It's not a practice that can be seen as alike to tango or to chess or. My
name is it's Juliano Maranhão from University of São Paulo. Well, my question is in line with Professor Shapiro and Coleman, and has to do with the ambitions of the project of legal theory. And I begin with a simple example. A question: Is it permitted, for instance, in Brazil, to kill your wife if she does not prepare the supper? Of course, it is forbidden, and I hope it is forbidden in Spain, in the United States. But the point is, there is agreement about the true reply to this question. It is forbidden. So this proposition is true. And this is the point. There is agreement between ordinary folks and judges and legal dogmatics to reply questions so prototypical about what is the response of law to these typical cases. So there is agreement to that, and there may be disagreement on legal theories to define what are the criteria to explain why this is true. Why are we so sure that this proposition is true? If we are sure about it, there must be some criteria, some knowledge behind it. Well, there can be agreement on the criteria, but there can be disagreement. But whatever the criteria are, in order to be a successful legal theory, it should explain why this proposition, which is true about killing wife, succeeds. It must succeed to show that the criteria include in the extension of the concept a case like this. Well, so there is agreement or disagreement among legal theorists with respect to ordinary agreement. But there may be ordinary disagreement too. And therefore, in these cases, which we may call hard cases, there will be potentially more disagreement among legal theories to reach a set of criteria. And you say, there may be an overlap of criteria among legal theorists, but this overlap will be too poor. It will leave too much which may be important outside. My question has to do, why should we be concerned to have a legal theory which will embrace everything that it is important? Shouldn't we be concerned to criteria in order to explain those cases of agreement? I mean, so we'll have something, but not everything. This is an idea which was the discussion between Boligin and Susan Hack concerning the application of logic to law. So, this criteria would, so there may be agreement, theoretical agreement on the criteria to explain, to have a concept which will succeed in include those agreements in law, but will not be an extension to an all-embracing extension. So should we have a concept to embrace everything? That's my question. So if there must be an engineering project, how ambitious should it be? How ambitious should it be?
Well, very ambitious indeed. If practical and political considerations are at stake, I think it should be as ambitious as possible. I'm not sure of having grasped the point, for linguistic reasons, the point of your answer. Well, we have three levels or three kind of questions. What law is, what are the criteria of legality, on what is true according to those criteria of the law of a certain community and a certain moment. So, we can have disagreements on the third level. Is it forbidden such and such or not? In Spanish law, no. Well, disagreement about this kind of questions may be disagreement easy to explain merely because some people are applying mistakenly the criteria of legality. Simply because of that, the student that answers questions in an exam wrongly disagree with our point of what is law in Spain about this point, merely because he is applying define wrongly the criteria for legality. I think this kind of disagreement is not very interesting. Other question is, there can be disagreement about the criteria of legality. Disagreement about these criteria may be grounded on a deeper disagreement about what law is. We can have a disagreement about the criteria of legality because, to begin, we have different concepts of what law is. And so the point is, concerning these two levels, it makes sense to talk about the right concept of law, which is ours or not. I think this is the point. And the nature of jurisprudence as usually conducted seems to be the task of identifying what is necessary. This is very arguable. Perhaps it's not the necessary what really matters. Perhaps a lot of things that are necessary features of law are uninteresting, are unimportant. It's necessary but unimportant. So we have to combine, in a certain sense, the notions of necessity and importance. But without a notion of what is important, what we have as a product of legal theory, of jurisprudential theories, what is necessary. But what is necessary, alone, important or unimportant, depends of what counts as law. And if there is no agreement of what counts as law, the very task of identifying through conceptual analysis necessary truths, I think is flawed. I'm not sure at all of having answered your question. I'm not sure at all. But in this moment is that yeah.
We only have time for 2 more questions, so I'm going to go to the front here, and then one more over here to end.
Yes. I would please ask you to elaborate a bit more on the difference between the second and the third version of the normative approach. Because in particular, with reference to the problem of objectivity, it seems that the problem you have with the third version of the normative approach is that they take it that, or they claim that legal theory should take it right to produce a certain result. You describe the result in terms of describing what they take to be a definite concept of law. I'm not sure that is right in the case of Dworkin, but what I think we will both agree is that Dworkin thinks that legal theory should take it right in the sense of providing the best account of what law is. Given that at the end of your paper, you accept that the question to the response to the question what the law is relevant to responding questions about what the law is. Isn't that enough reason to accept that legal theory should take it right? Should take it right, the task of providing the best account of what law is. So, again, I would like to, if you please could elaborate on the difference between your position and the third one.
I think they are different indeed. I think that, for instance, in Dworkin's sense, in the sense of what Dworkin would call the doctrinal concept of law, there is a concept, doctrinal, that can or cannot be get right, even at the point that it seems to me a consequence of Dworkinian account that I don't share at all, that there is the possibility, on Dworkinian's account, of global error about law. Everybody could be mistaken about what is really law. Reasoning from Dworkin's premises. To me, this makes no sense, but this is a consequence of the Dworkin's account, that there can be global error about law. Perhaps nobody realizes what is that follows from seeing in its best light the data of the practice. Of course, Dworkin seems he is seeing in its best light the practice, and so what follows from that. But in its theoretical presuppositions is implied that as a possibility, perhaps nobody is right about what is law. And I think this is a great difference between this approach and mine. In my approach, this makes no sense at all. At least that. Moreover, I think that in Dworkin's or in Feeney's account, the idea is there is a right, correct concept of law, and to identify it, we need to make some moral, substantive assumptions about what is the purpose, the point, the worth of the practice. I don't share this point of view. To my mind, what is arguable, in fact, what I think is false, to begin, is that there is a concept of law to get it right. To my mind, the difference between the 2 1/3 of the senses of normative jurisprudence in the order they are presented in the paper, to my mind, this is clear, at least for these considerations, for these two kinds of considerations.
I think we've asked a lot of great questions today, and we should thank Professor Bayón for his excellent paper.